But no, I won't subject you to that, because I think you want me to do later on a little excursus on the rule against perpetuities, and just to wake everybody up. I've got to tell you, ladies and gentlemen, when I was an equity judge for 10 years, and I still don't understand the rule against perpetuities. Although I've written a number of judgments. And that little book that you have, I wrote that in about 1991, 92, the purpose being really to instruct my own profession in what mediation was all about, because the sad thing about lawyers is any innovative thing, to start with, they don't even want to know about it. So I wrote that, and I polished it a bit as the years have gone on. I'd have called it mediation in a nutshell, except for copyright reasons I couldn't get away with it. I don't know whether you ladies and gentlemen still subscribe or purchase the nutshell books as you went through your law course. I know you wouldn't admit it, no doubt, in the presence of your mentors, academic mentors, but we do contracts in a nutshell, torts in a nutshell, commercial law in a nutshell, and I got through 10 years as an equity judge on the strength of equity in a nutshell. They're wonderful books. But I couldn't call this mediation in a nutshell, but that's really what it is. And that, in many ways, is probably all you need to know about mediation, because it's a philosophical approach to conflict. And the more you proliferate out, the more you obscure that basic human element, that this is all about a human interactive mode that you're trying to resolve in a way which involves concessions on both sides. And people don't like making concessions. The longer a dispute has gone, the more deeply they become immersed in their own emotional commitment to it, the more money they've spent on it, if it's in the hands of litigators, and the harder it is to dig the parties out of that. But that's really what one's trying to do in a mediation, to address the deeper emotions, and that's why I say you have to put fairness out of account and just concentrate on what's going to be achievable. Now, what I said I'd deal with a few examples. One of the easiest disputes that I became involved with was not long ago. It was a classic building case. A man, a commercial company had employed commercial builders to build them a factory outside Gosford, just a little bit out of the centre of the city. And this factory had been built and, according to the builder, completed. The owner rejected it, found a whole raft of defects, so there was a dispute. The builder was claiming extra payments, and the owner had a cross-claim for defective workmanship. Classic building case. Well, it came into mediation, and the list of defects that the owner prepared, supported by expert evidence, was as long as your arm. Pretty well everything that could be wrong with this factory. It was a real dog of a job. Well, meanwhile, the owner wouldn't take possession of it, so the factory remained empty out there in the bush just outside Gosford. And as often happens with empty commercial buildings, a resident hobo who lived in the district came and set up camp in the building. And again, as often happens, he had a whole lot of newspapers and rubbish and so on. And one night all his rubbish caught fire, and the factory was burnt to the ground. Now, suddenly, this factory, which the owner said was an absolute dog of a dreadful job, was converted from a real asset into a claim under his insurance policy. So suddenly all those defects dissipated. The factory was a state-of-the-art job. Word came down, destroy all those, or send back all those expert reports condemning this factory. The parties have settled it. Because the last thing, of course, that the owner wanted was his insurance company to become aware that the factory wasn't as good as he was representing it as being. So without necessarily being party to an insurance fraud, I happily sent all the papers back, because it was a dreadful dispute anyway. But it was amazing how quickly that building, overnight, turned into an absolute wreck of a building, into a magnificent job that was glistening with all the latest modern technology and equipment, all through the action of that hobo. And I told that story not long ago in a building science forum, and a voice from down the back, "Say, where's that hobo? We could use him." But that didn't require any mediation. That was solved by the intervention of nature. But I was going to pick out one or two cases that I was involved in. A recent one, probably one of the hardest that I've done, was in London last year, a dispute over 17 sets of Aboriginal human remains that were in the custody of the Natural History Museum in London. How they had come to be there was questionable, but these 17 sets of Aboriginal human remains were part of the prize collection of the Natural Science Museum. Tasmanian Aboriginal Council wanted to recover them, and the museum wanted to retain them. There were 3 court cases pending in the High Court in London about these, the recovery of these Aboriginal human remains. The museum played every card in the pack. I can talk about this. I'll tell you why later on, but I can tell you the whole story. I'm not inhibited in the slightest degree because, well, there was no mediation agreement signed, so there's no confidentiality, express confidentiality agreement. But the museum had played every card that they could. They had challenged the title of the Aboriginal Council to these remains, so they had to get a special grant of probate in the Victorian court, or in the Tasmanian court, so that they did have title that they could propound. But it was not clear at all how the museum had come by them. It was generally accepted that they had probably sent people out on contract to dig out some remains and bring them back, and that's how they'd accumulated them. Well, this dispute was well on its way through these 3 cases, well on their way through the courts, and it came in for mediation. Now, when I describe it as difficult, it was difficult for this reason, that the Aboriginal Council had a deep cultural commitment to the proper consecrating of the remains, otherwise their ancestors would not be at rest. And they, the living Aborigines, would not be at rest if they hadn't done their duty by getting hold of their remains and consecrating them. So they were serving a higher cultural imperative. Trustees of the museum, on the other hand, had a high cultural imperative. These were valuable scientific resources which could have general value for science. So they had a higher cultural imperative. And that's why it was a difficult dispute, because you had 2 totally bona fide cultural imperatives that were at loggerheads. Not the sort of thing that either side could really compromise much on. Well, the breakthrough came happily that there were 4 vials of genetic extract from these skeletons. And the whole core of the dispute really settled on that genetic extract. The skeletal remains were not so significant. It was possible to photograph them, take plaster casts and send the originals back for proper consecration, but there were these 4 vials of genetic extract. And that brought a problem of its own, because the Aborigines are paranoid about the use of genetic research to try to demonstrate that they're inferior beings. Stone Age man is a sort of inflammatory suggestion. So they weren't at all happy about this resource being there which might be used to discredit their race. Well, happily, some years ago, Fred Hollows, a name that might ring a bell with some of you ladies and gentlemen, had been able to work out a cure for a genetic Aboriginal eye disease by reference to the inheritance and hereditary research into them. And Fred Hollows' research depended very much upon this genetic makeup of the Aboriginal people. And it was by no means out of the question that perhaps in the future there could be other diseases or illnesses to which the Aboriginal race was peculiarly subject, where research into the genetic material could be of great value to the Aboriginal race. So suddenly there was a point in common. Great value in this material for the Aboriginal race and for human beings in general. And out of that commonality of interest, we were able to structure a settlement that involved the skeletal remains coming back and being properly consecrated. The 4 vials of genetic extract were sent back to Tasmania, to their homeland. They're in safe custody now in Tasmania in the names of the museum and the Aboriginal Council, not to be used without the consent of both parties. So they've been preserved for the benefit of future scientific research, which could be of value to the Aborigines and to the human race in general. This genetic extract is safe, but it was just a a fortuitous circumstance that Fred Hollow's research was able to be called in aid to find a common point between the two sides on which we were able to build a settlement. And it's a very good example of the way in which, if you dig about enough in disputes, you can often find a common element that both sides are prepared to seek to pursue and which will lead them to relinquish other less central claims that they may be making. Now, the reason I can talk about that is that I just use the word a lawyer for the trustees who didn't know anything about mediation, didn't realise, and who was opposed to the mediation anyway, because these cases were well underway and it was going to be, an interesting legal case. Didn't like the idea of the mediation at all. When we started, he took objection to the Aboriginal representatives sitting around the table, which I introduced as they're representing the Tasmanian Council. He said, well, how do I know? I said, well, look, they're here, they've got senior counsel, had senior Australian Silk, Geoffrey Robertson was appearing for them. He said, they've got their senior counsel. No, I'm not, I want something in writing. So we had to adjourn for half an hour while emails went to and fro until something came back in writing which satisfied his requirement. He was trying to hold it. I only had 2 days available to do this mediation in London, and so he was sort of trying to play out time. I knew as soon as I produced the thought of signing a mediation agreement, there'd be more objections, so I didn't produce a mediation agreement. I didn't need one. The Commonwealth Government was paying my fee to go over there, so I was all right financially. And, of course, the great value of the mediation agreement normally is the confidentiality provision. So that one went through without any express confidentiality agreement, which is why I can talk about it. So happily, it's not lost in the midst of inaccessible mediation material. One can identify it as an actual case and use it as an example of the need to try and find some element of commonality that both parties will embrace, no matter what their dispute may be. If you can just find that common ground and then structure your settlement on that, that's the way in which to get inside a dispute. And I mentioned, it's a good example of that. I mention it not out of a sense of self-aggrandizement, but it's one of the few really big ones that one can talk about. The need to find that element of commonality that really exists in all disputes. Parties find it hard to back away from their belief in what's right and what's wrong. I can give you an example. This is quite an amusing one. At least I think it was amusing. I thought at the time it was amusing, and I still think it is. It was a dispute between within the accountancy profession. Now, I have deliberately, totally anonymised this. You'll never be able to identify it for obvious reasons. You'll realise why I have to preserve total confidentiality. But we'll say in the accountancy profession, two middle-sized firms, one had headhunted from the other the woman who headed up a particular department, we'll call it the tax department, to come over from the firm where she was a partner to join this firm, to bring with her her immediate colleagues and her client base. Well, the deal went through. She moved across to this other firm, and about 6 months later, all hell had broken loose. The firm that she'd joined was complaining bitterly that she hadn't brought her clients, and what's more, she was an impossible, difficult woman. She'd totally destroyed their office morale. They'd had a happy, macho group of men running their practice, off to the footy on Saturdays, Friday night at the pub, and so on. A real male chauvinist den, if you like, in this. And this woman had come and stayed. Now, I've got to tell you a little bit about the personalities. The woman, or late 40s, a superb professional. You can visualise the type. Perfect, wonderful designer gear, perfectly coiffured, manicured, and so on, but hard and tough as ice. They're terrifying, those businesswomen. They always used to frighten me. As a barrister, they used to frighten the hell out of me. You can't get them on the run in the witness box. You know, they can't. Yes, Mr. Street. No, Mr. Street. Just, again, it sort of makes you feel like a schoolboy in short pants. They take control of the court. And this was one of these. She was a real Devil Wears Prada, if you like. And there she was, and a superb businesswoman. as so often happens. So this was this one. The senior partner of the firm that she joined was a total opposite. He'd say straight out of the second row of the Canterbury Bulldogs. A thick-necked, ugly-looking bastard with ears and nose, and a dreadful-looking man, a real oaf. And if ever two personalities were made to clash, these two were, and they hadn't. It was a beauty. The firm that she joined was riven with this conflict. They said she'd introduced office politics, and she said they were all bullied. It was a huge dispute. Off in the federal court, fraud, false and misleading conduct, and so on. Each side had hired a top trial lawyer to carve the other one up in the witness box. She had a dirt book to use for cross-examining the senior partner, all the sins of omission and commission that he'd been guilty of, and so on. And this was going to be a magnificent fight. Well, it was sent in for mediation, and as it was being, we were sort of foregathering, solicitors remarked to me, you're not going to be able to settle this. That was all I needed to spur me on to reckless limits of extravagance. Well, we sat down, each side of the table, about 8 down each side of the table. The senior counsel for each side, and their juniors and the lawyers, and in particular the woman and the Canterbury Bulldogs man, glaring at each other across the table. Started off, passed the ball. Now perhaps she outlined no more than 15 minutes, so he held forth all the things that had happened to his client over to this side, and senior counsel for Canterbury Bulldogs held forth. And I said, well, now perhaps you could go to your rooms and I'll come and talk in each room. I went into her room. Look, I want you to make clear to that dreadful mongrel what we're going to do to him. By the time we're finished with this case, he'll rue the day that he ever met me. All the things that he's done, I want you just to out it all. I said, look, I'm not going to go and tell him that. To start with, you've seen the size of the man. I'm not going to go and abuse him. But anyway, I said, okay, I'll take into his room. That hard-faced bitch. She ruined our professional peace and quiet here. She's brought all of this women's lobby, politics and so on, and she's destroyed the peace of the firm. But we've just got to get her out of our hair there. But I want you to make that clear to her. And I said, look, I'm not going to go. There's no point in my telling her that. She's not going to take it from me. I said, there's only one way that we can get this in each room. I said privately, Miss Smith, I want you to come in with me, and Mr. Brown, and the three of us will sit down, and we'll have it out. Lawyers were very reluctant, particularly the senior counsel. Oh, no. I said, look, who's running this mediation? So I got the two of them, sat them down each side of the table. I was at the head of it. I said, now, Miss Smith, I know there are things you want to tell Mr. Brown as to what you think of him and what some of your experiences. And Mr. Brown, by all means, you come chip in as and when you want to. Don't listen in silence. I know there's things you want to say to Miss Smith. So let's have it out. So she started off, and I said, from time to time, and didn't he do that, and didn't she? It was gradually hit. It was wonderful spectator sport. Wonderful. I won't say that I learned any new four-letter words, but I did learn how to use them in more devastating combinations. Just ponder on that for a moment. Well, after about 40 minutes, a dramatic thing happened. Devil Wears Prada collapsed. Mascara all over, everything, awful mess. Canterbury Bulldogs, his face was, I thought he was going to have a heart attack. So I said, well, I think, ladies, we've gone far enough. Perhaps you'd go back to your own room. Went into her room. She said, look, now you've seen what a dreadful bastard he is. I'm glad I had a chance to tell him that, because nobody's ever stood up to him. He's a bully. He needed to be told that, and I'm glad I was the one to tell him. But look, I can't face sitting opposite him in court for 2 or 3 weeks. For goodness sake, get the case settled. Into his room, much the same sort of thing. That hard-faced bitch, everybody's frightened of her. She freezes them off, and nobody's ever, pulled her into line. And I'm glad that I was the one to do it, but I can't face sitting opposite her in court. I want to get on with my practice. For goodness sake, get the case settled. So I took the two teams of lawyers out and I said, well, now, ladies and gentlemen, I know you've each got instructions to settle it. How are we going to settle it? And with the aid of the lawyers, in an hour or so, we had a settlement deal in place. Now, that's a very good example that at times parties have got to be encouraged to go to even greater extremes in their anger and their aggression before they're ready to settle. These two were spoiling for a fight. It was much more rewarding for them to be able to do it themselves than to have to pay a fortune for senior counsel to carve the other one up. But I could see at once that this was a pressing need. They had to get this off their chest. Now, it's not good mediation practice, and I don't commend it to you to emulate, because you don't normally try and whip up hostility in a mediation, but I knew that they had to get that off their chest before they'd be ready to settle. And sure enough, we did. We got a settlement out of it. And it's a good example, I repeat, of the need to identify what's the imperative which is driving the parties in this dispute. Normally in a mediation, I go out of my way to develop goodwill between the parties. And I always say to them jointly, look, you may think that you're in the hands of a legal group here, because we all know each other and there's a certain amount of goodwill and courtesy. I said, I encourage goodwill and courtesy because that's the way you get a deal. And I go back to my house analogy. I say, if you're going to go along and buy a house, you don't go along and abuse the vendor. You go along and you try to develop an element of commonality in getting a deal. So that particular example is in the teeth of what mediation is normally on about. Mediation is normally on about generating a climate in which a consensus can manifest itself. But I repeat, it's an extreme example and not one that I urge upon the faint-hearted. Now, I've got a list of some other ones here that I thought might just demonstrate some other points. Mediation, as I said earlier, is an endlessly variable process. And the mediator will craft the process in order to meet the expectations of the parties, the personality of the parties, and the nature of the dispute. And that's very much part of what one seeks to do in a mediation. Often, or almost always, parties are reluctant to recognise that there are defects in their own position and strengths in the other side's position. They get holed up in the I'm right, you're wrong, or the heads or tails of it. And they don't like admitting that there are weaknesses. A very good example of that, before I come to talk about another mediation, was in the late 1800s in London, when the new courts of justice were going to be opened by Queen Victoria. That magnificent new structure in the Strand, and Queen Victoria is going to come. I should have turned that off. I've got a new phone and I haven't learned how to work it. I was given a complimentary iPhone, which I can't use. My daughter's latched onto it now, and I've got an El Cheapo that I can't use. Queen Victoria is going to come with all the pomp and ceremony of the late 1800s to open this magnificent new complex. And the judges had met at a judges' meeting to approve the draft of an address of loyalty the Queen was going to be given. One of those wonderful things with pumpkins and scones around fruit around the outside, and florid language and so on. And this was the address of loyalty the judges were going to give the Queen. And the draft started, "We, Your Majesty's judges, conscious as we are of our manifold defects and weaknesses, present to Your Majesty our loyal and..." My judge said, "Just a minute, I'm not conscious of any manifold defects and weaknesses." "No, we can't say that's absurd, holds us up to ridicule." Conscious of our no, that's got to be redrawn. That's going to destroy confidence in the judicial system, conscious of our manifold. It's got to be redrawn. Sent out to the draft person to redraw it, came back with a small but very significant amendment that resulted in total acceptance. "We, Your Majesty's judges, conscious as we are of each other's manifold defects and weaknesses," unanimously acceptable. We're always prepared to recognise defects on the other side of the argument. We don't like recognising them ourselves. So in a mediation process, one seeks to avoid confronting either party with the need to acknowledge that there are weaknesses. One focuses totally on the outcome, on what is achievable. What's the best way to get a result? I often used to use, as an example, a U-curve. If you take the two parties, they get into a dispute, and they come up to the edge of in its early days, to the edge of a sudden depression. Now, that is a good time to try and settle, early in the dispute if you can get it settled. But if it goes over the edge and they get down into litigation, they spend money, they become emotionally more committed to their point of view, until you get down near the bottom of the U when it's almost intractably locked into a battle. And then as a mediator, you've got to get them up the other side of the U to a level where they are prepared to be objective. The way in which I do, and this happens not infrequently when matters are sent in by a court for mediation, when the parties are deeply invested in the court battle. I always say to the parties, now look, how are we going to find a way to get a fresh look at this dispute? Move the initiative over onto the parties. That's what a mediator should be doing all the time. You're moving the initiative over onto the parties. You're not imposing it yourself. You're trying to lead them with you. No, I won't say it because I'm going down on film here. I was going to give you a little analogy about what a mediator tries to do with parties, but you've got to get them to come with you. Well, I may as well say it. The art of mediation is the art of seduction. You've got to get the parties to come with you. And if you try and tell parties, and that's why judges don't make good mediators by and large, try and tell them, they'll bail up on you. So you enlist the aid of the parties to try and find how can we climb up out of this pit of this U, up onto some upper ground where we can get a settlement. Now, that involves using the parties themselves to point the way forward, rather than the mediator pointing the way forward. Mediation, in a sense, is the exact opposite of litigation. An efficient judge will get rid of all the small stuff and go straight to the killer point. Say, well, Mr. Smith, look, unless you can get up on this point, you haven't got a case, have you? So you look for the killer point and you decide that, and then you get on, as I said, call the next case. Now, in a mediator, you don't look for the killer point, or at least you may look for it, but having seen it, you move it onto the side. You get the parties to engage even in trivialities. When are we going to do the mediation? Ladies and gentlemen, what's a convenient date for everybody? Where will we do it? Now, what preparation, what do you suggest, Mr. Smith, that we should have by way of documents? Mr. Jones, get an interactive mode going between the parties, quite remote from what their real issue is, so that you've got an atmosphere of engagement in a process which is ultimately going to lead, hopefully, to interaction on the big matter in dispute. Now, that's not what you do as a judge. In fact, you don't waste time as a judge skirting around the edges. You go for the central point, you hear the argument, look at the evidence, and you give a judgment. Now, that's not mediation, because in a mediation, I repeat, you've got to use the party's willingness to communicate around the periphery and, in effect, creep up on the big issue. Quite often parties will come into a mediation and say, look, we've been sent here by the court, we're not going to settle this case, it's a waste of time. And I would say, well, look, you've been sent here, let's just see if I can help you, perhaps with some case management. We may be able to get rid of some of the small stuff so that you can then much better concentrate on the real fight that you're going to have. And bit by bit, you can often refine it down until it turns out, well, why can't we have a go at the big one? And then the parties, by that stage, are interacting. You've got a matrix you've agreed on, and then you can address the big point. I'm putting this in very simplistic terms, but that's the way in which one, as a mediator, tries to deal with matters where parties are deeply entrenched. But going back again to the need to get the parties to engage, I always, at an appropriate stage in a mediation, emphasise this business of understanding. You have to understand where the other side's coming from. Now, that's where I use my 50-cent coin. I can give you another couple of examples, ladies and gentlemen, which I think are useful in relation to this element of understanding. I'm going to hold something. You know, this came out of my now teenage daughter's primary school. So it's elementary. If you know it, don't blow my cover, because I'll make a point from it that I think may not have occurred to you. I'm going to just show this to half the room. Now, what did you see on it?
Princess.
Now, I'm not asking about you to fantasise. You're not doing too badly anyway with your neighbours there. All right, princesses, and old lady. Sort of a bad hair day. Sort of thing that comes to all of us eventually. Old lady, would you agree on that? Well, now, this is not very clever, but it has a very useful point. There's the old lady. And there's the princess. Now, it's not clever, but it's got a very good point that I want to make. In fact, what I showed to both halves of the room was that. I showed you a set of interlocking lines. And according to your predisposition, your susceptibility to fantasizing or whatever, there was a princess to this. And there was an old lady over here. But in fact, it was a set of interlocking lines, which according to how you look at it, was a princess or an old woman. Now, it's a 50-cent coin again. How are you looking at this dispute? You're looking at it with a preconceived view, one way or the other. And what we've got to do, and this is, we often use this sort of description in IT disputes. IT disputes often say, well, look, let's assume we've got a bowl of cooked spaghetti. We've got to lay out the strands of the spaghetti in lines so that we can look at it and get it into perspective. Now, those interlocking lines there have just got to be laid out so that you can get a better hand and you can recognise that there is some legitimacy in the other side's point of view as you try to move down the path towards getting a deal. I'm sorry that I'm limping around, ladies and gentlemen, but I did a knee-in on the snow more decades ago than I like to say, and I've got to limp around a bit. I'm getting a new one in December. And now I decided to get a new knee. My old knee has rebelled as much as to say, well, look, I looked after you for all these years, now you're going to get rid of me. But I've got to, that's why I'm limping around the place. But it's a good example of understanding. You've got to understand that the other side is seeing this thing differently. Let me give you another example. Let's say this is a 10-ounce glass. And we'll say it's got 5 ounces of water in it. I'm asking you just a minute, it's more than that, but let's say it's 5 ounces of water in a 10-ounce glass. Now, some people would describe that glass as half full. And those we like to think of as the optimists, the positive thinkers. The glass is half full. Others would describe it as half empty. We think of those as the pessimists, or the glass is half empty, the negative thinkers. In fact, both descriptions are totally reconcilable with complete intellectual validity. If I just give you one more example. The glass was empty, and I've poured 5 ounces of water into it. It's half full. Or it was full to the brim, and I've drunk 5 ounces. It's half empty. Message, how does it come to have 5 ounces in it? How does it come to have that in it? Just look behind it. Look outside the square. And then it's totally... You don't go around at a party with a bottle, a man with a glass of beer that's half... It's an 8-ounce glass with 4 ounces, and say, hey, your glass is half full, let me top it up. Your glass is half empty, you've drunk half of it. Now, how did you come to have 5 ounces in it? Now, what at first sight appears to be a total conflict of description is utterly logical, totally intellectually acceptable if you know that extra element of how that came about. Now, that's understanding. Think outside. Look behind it. Don't just take it for granted that it's got 5 ounces in it. How does it come to have 5 ounces in? Now, let's both of us, ladies and gentlemen, you, parties, and me, let's just see how you came to be in this position. And if you can move down that, how you came to be, then you can often get the breakthrough to get the parties interacting. Quite often when you get two parties at loggerheads, as a mediation has run on, and you reach a stalemate and you can't... each side is not, neither side's prepared to move from where they are. I'd often say, well, look, just let me take the two principals, the two chief executives, because most of my work's commercial, so this is not really relevant in the family arena. I get the two chief executives. I said, "No, look, gentlemen, I'd like you," because they're nearly all men, although we are improving in this country. I'd like you just to discuss where you're both at. I'll leave you on your own to see if you can find some way out of this impasse. It would be a great pity if you both go away from here without a resolution. I'll leave you here, and please just spend a half an hour going over everything that's in issue. I'll wait outside here. Please come and get me. Come and get me when you've finished your discussion before you go back to your own room. Now, I know they'll either quietly get it settled between them, that would be the best of all, or else they won't. They'll dig in further still. So when I go back in, when they get me to go back in, I ask each one then to recap. Now, just can you briefly recap how the discussion went? And can you then, let's just have a recap. Now, subtly, each side will give an account which was more reasonable than the approach that they were making to the other side, because they want to appear to be reasonable in the eyes of the mediator. So each side, with that little bit of subtle pressure, will put a more reasonable point of view, and quite often you can see then, hey, I can get a breakthrough there that you can then use. It's unlikely that they will resume an unattractive snarling at each other with the mediators in the room. They'll be much more civilised in their account of it, wanting to appear that it was the other fellow who was being unreasonable. And you can then often see the chink that you can use to bring them together into a consensus. It's quite a useful technique that if parties do dig in and you have a stalemate. But essentially what you're trying to do, you're trying to provoke the parties to commit themselves to a point of view. Now, another mediation I'd like to give you in the limited time available, and then I'll stop and expose myself to cross-examination. It was a dispute over the new trains for the Sydney suburban lines, and this was about 10 years ago. And I'll interrupt myself for a moment to say I've got a train analogy that I often use when contrasting, when warning people off litigation. I say to parties, look, let's just imagine litigation as a train. You're going to get on board a train that's called litigation, and you, the plaintiff, you buy a ticket, and this ticket says big win for the plaintiff, and you get on board. The defendant gets on board. The defendant buys a ticket that says win for the defendant or minimal win for the plaintiff. You've both got two different tickets. You're on the same train. You're on the same court case. Now, you're going to two different destinations. Now, neither of you is on a guaranteed outcome, because we trial lawyers can't guarantee an outcome. No lawyer can ever guarantee an outcome. We're great at the weasel words, which are all very strong cases, but if your client says, will you guarantee? No, I can't guarantee it. So neither of you is on a guaranteed journey to win for the plaintiff, win for the defendant. What's more, you've lost control of the dispute because this dispute's in the hands of the court now. You can't drop your claim. You have to get a default judgment. The defendant can't walk away from it as a default judgment. It's out of control. The case is in the control of the judge who's going to hear it at the end of the day. The judge will say jump and you say how high. Because the judge is in total control of your dispute. And she'll control the hearing and give the judgment and decide which one's going to win the case. So it's out of control. Now put those two things together. And this is a real New South Wales train special. You're on board a train with no guaranteed destination and the driver's out of control. Now that's really what it comes down to at litigation. When you take it apart, you haven't got a guaranteed destination and the driver's out of control. And most people would say, hey, I want to get off. So here it is today, ladies and gentlemen. I can take you about it. We can get off the train. The train stopped for the moment. We can get off the train if you're both prepared to make the concessions that are necessary. It's quite a good little analogy just to jockey parties out of what is a very flattering but unfounded confidence in the litigation process. You can never be a guaranteed outcome, and you're not in control of it. And so you put those two things together, on board a train with no guaranteed destination and the driver out of control, it's a New South Wales special. We live with that train system every day of our lives. But now, that's a very good warning off it, but let me come back onto the Tangara trains. These trains were was a huge contract, was let to replace all Sydney suburban trains about 10 years ago. I can tell the story because it all came out in Parliament. They were going to be delivered in 4-car sets over a period of about 5 years. And for a variety of reasons I won't go into, but they were not altogether free from politics. That's why it all came out in Parliament. Things had gone horribly wrong. It was a schedule of rates contract, and the rates had proved to be inappropriate for the way in which the job was going forward. Well, it came in for mediation. Each party, they had about 15 on each side of the table, experts and so on. And it was possible to identify categories of dispute. One was the schedule of rates. Another one was the specification. Anybody who's had anything to do with construction disputes know that it's axiomatic. The specification will be either unintelligible or ambiguous or uncertain. Specifications always are. Anyway, and this one was a beauty. So schedule of rates had proved inappropriate. The specification was a real difficulty. And there were also some other peripheral issues. Well, as to how the contract was to be construed. Well, at an early stage, this mediation stretched over about 3 months, but probably with about 10 days of actual mediation meeting. We set up a working party of quantity surveyors to redraw the schedule of rates, because the contract still had a long way to go. We set up a working party of consulting engineers to redraw the specification. Contract itself had some ambiguous clauses. We readied up the essential one to be taken into the court for a declaration. Competent commercial judge would have heard the argument on half a day and given an oral judgment after lunch as to what the clause meant. So that was going to go into the court. We were going to use the court declaration as part of our building blocks for the settlement. As it happens, there was another clause equally obscure and equally difficult, and they traded them off against each other. But the relevant point was we could have used a declaration from the court as to what the contract meant. Judges are doing that every day of the week. As an equity judge, you're doing it with wills, construing wills. There's nothing very novel about getting a declaration as to what the clause of a contract means. But we didn't have to because they traded them off. Meanwhile, we had these quantity surveyors and the engineers working through the claims. It started off with about 600 items in dispute, over 100 million on each side, claim and counterclaim. So big figures and multiple incidents going to make them up. And we had reports back about every week from the working parties. Well, ultimately, after about 5 or 6 weeks, they had got rid of all but about 50 quite difficult points. So we set up these 50 points, and we were going to do those as a mini-trial type process. We'd used expert determination for an argument about the quality of the steel, so we had resolved that with an expert determination, but we had these 50 intransigent points. So it was a mini-trial type process. I don't use the word mini-trial because you frighten commercial people if you talk about a mini-trial. They don't know what it means, and they back off from it. But that's in effect what this was. We structured the agenda, had the 2 teams down each side. The arrangement was I'd set up the top of the table with the 2 chief executives each side of me, and we'd take them one by one. We'd have 10 minutes on each point to exchange to see if they get a deal. Now, this was about 5 weeks down the track in the mediation, in the course of which over 500 matters had been resolved. So already there was an investment, a success for over 500 items, that the motivation to try and get the rest of them was fairly strong. So I structured the agenda to put the easiest of those 50 up the top. We took the first one, 10 minutes, 5 or 10 minutes for the experts, and then the 2 chief executives conferred. Now, they were not going to let what had been achieved with the other 550 items fall over because they couldn't get agreement on that first one. The pressure on them to agree was quite intense, and so we got agreement on the first one. Same with the next point. After about 4 or 5 points, it had become like a game of tennis. One chief executive said, well, if you had the last, this is my turn. So much for this huge dispute, which was going to bog down the construction list for months. And every one that we got in place was another investment by both parties in a successful outcome, which made it harder still for the chief executive, either chief executives, to be seen by their colleagues up and down the table as having blown the settlement. Well, to cut it short, after 3 days of this process, we had them all in place. The whole thing was settled. Now, I cite that one because it's a good example of the way in which you can combine different techniques. We had an expert determination about the quality of the steel. Parties agreed to be bound by that. We had a non-binding determination about another element that they agreed they would use as a building block. There was a great argument about what the costs were of the factory. We've got a non-binding expert appraisal of that they agreed that they would use for the purpose of the discussion. And we could have used the court's declaration. We had a range of things we pulled in to cast light on the matters in issue, and then we isolated out the remaining points. They agreed, as I say, with over 500. They got agreement. We had the other ones isolated, and with a very significant investment by both sides in actually getting the deal, and that investment focusing the heat onto each of the chief executives in front of their teams, which was perhaps a little unfair to them, but they settled up to it manfully nevertheless, and we got the deal. Now, it's a very good example of the way in which you can combine different techniques in order to get the resolution of something which looked at the outset to be almost impossible to get inside. We had a working parties, they reported back, chief executives agreed to accept their reports back, and in effect it created an interactive mode on various aspects of the dispute which was able to be ushered down the path towards a total consensus. Now, it's a good example of that because so often these ones you can't talk about, but this all came out in Parliament because there was talk of political interference in the contract, all sorts of political background, if you like. So that's how this all came out, that's how I can talk about it. But it's a good example of the way in which you can use different techniques in mediations. You're not stuck with just one technique. You use whatever techniques are going to assist to bring the parties down the path towards a consensus.
My name is Kirsty. I have two questions today. My first one here is, in 2006, David Spencer and yourself published separate articles discussing the role of mediators of the judiciary as the role of members of the judiciary as mediators. What thoughts and criticisms, if any, do you have of David Spencer's paper, Judicial Mediators, Is a Time Right, Parts 1 and 2?
You can be a good judge and a poor mediator, and a poor judge and a good mediator. The qualities are totally different. The judge's quality is decision, getting rid of the small stuff, going for the killer point and deciding it. It's not what you do as a mediator. A judge isn't concerned to carry with him or her the personal goodwill of the parties. You're concerned to do a professional job of judging. So the skills you need for that and your years of experience and training tend to make it almost impossible to make the switch without a major overturn, if you like, in your philosophy. And you'll find there's not many retired judges who are in fact making a success of mediation, because the qualities are different. The qualities of a mediator are the ability to empathise and the ability to approach with due humility the attitude of the parties. I said at an early stage, quite often you think the parties are appalling people and deserve each other, but you can't let that appear. As a judge, you can let it appear. Some judges are a little bit too forthright at times. But a judge isn't concerned to ingratiate himself or herself with the parties, because you're not trying to carry the parties with you to agreement. You're giving the parties the benefit of a judicial determination of their dispute. So the qualities are different, and I repeat, you can be a good judge and a poor mediator, and a poor judge and a good mediator, and all points in between. So it's simply that the roles are different. Now, confusion has crept in by this phrase, alternative dispute resolution. I published an article on the ALJ about it, trying to get away from this alternative dispute resolution. It's totally misleading. It's not alternative to anything. And it postulates that the courts are resolution bodies, and as I said earlier, they're not. I prefer to regard ADR as a self-contained description of the philosophy of resolving conflict through consensus. That's what ADR means, philosophy of resolving conflict through consensus. And we shouldn't be trying to put words onto it. We don't put words onto, TB, that's a bit old hat now. We don't put words on HIV. We know at once what they mean. Many of us don't know what CC means at the bottom of the letter when you put CC onto it. It's the most wonderful anachronism. It means carbon copy. Well, who on earth makes carbon copies these days? But we know what CC means, and we should just recognise that we know what ADR means. It's a philosophical concept that focuses on the resolution of conflict through consensus. That's it. And it's not helpful to call it an alternative. Still less is it helpful to suggest that the court is involved in resolution.
You've kind of already answered the second part by saying what are your thoughts on the ability of a judge to act in the capacity of a mediator?
Today, Edith Kogwabi. Firstly, the present system is that if parties agree in mediation and they do not agree in settlement, they can go back to the court. Usually the parties can't use any matter discussed during negotiation. However, why can't we have a summary of the matters agreed to by the parties to narrow down the debate in the court?
To start with, this rule of not using anything that's been used in the mediation is founded on the essential requirement that parties have got to be totally free and uninhibited in the mediation discussions. If either party is inhibited by the awareness something might come back to haunt them, there's not going to be a free flow as they move down towards a consensus. It'll be a consensus which is affected by the thought somebody else is going to later on think whether I was being unreasonable or not. Parties in a mediation have got to be totally uninhibited in the way in which they move down the path towards consensus. So that's the reason that underlies the universal rule. In this country and America, countries that are used to mediating, the universal rule is you can't use in the court what's said in the mediation, and it's part of our common law tradition without prejudice correspondence and discussions. So that's the reason why you can't use it in court. Now, how you get the parties when the party's already on to come to the mediation table, well, if you take that one of the accountants, the two accountants, they didn't really want to mediate. It was sent in. They wanted to have a good bash in court. They'd got, trial counsel. But once they saw a way through to be able to satisfy their innate hostility to the other individual, they were content to go along that path. That's up to the mediator to identify the subjective motivations of the parties. And really you can't generalise any more than that.
Thank you.
Yeah.
Secondly, there are cases where the referee has erred in law. Is there a system to check this?
No, that's in the building industry. That's expert. That's the building. It's not mediation.
It's not mediation?
No.
Would a mediator such as you give some legal advice to the parties had they not been represented? For example, would or could you have suggested to the chef in sous chef that the dragon, as the student calls it in inverted commas, may well have a chance of succeeding with the injunction if he in fact believes so? What power does a mediator have if they are a lawyer themselves and the parties do not have representation?
Well, as a mediator, you have to have the humility to keep your own opinions right out of the question. You're not there to give a legal opinion. If there's a matter of law involved and you feel a party is in need of advice, well then they've got to go outside elsewhere to get it. You can't, as a mediator, as I call it, play God. You can't sit up there and look at the whole lot and say, well, I think you ought to do this and you ought to do that. The parties have got to be able to find their own way. And mediators don't give legal advice, because to give legal advice, inevitably you'd be favouring one party and disfavouring the other. There's no such thing as legal advice which is right down the centre. If it were relevant, then there'd be no conflict. So mediators don't give legal advice. And that's an unwritten rule from my point of view. Also, when I left the bench in '88, I didn't take out a practising certificate, so it's illegal for me to give legal advice. And in more practical terms, there's a lot of water gone under the bridge since 1988, and I don't claim to be a lawyer. So mediators don't give legal advice.
You said earlier in your speech that courts are not user-friendly to resolving disputes. Do you think that the judicial system has or will have the capacity to appoint trained judicial mediators, or should it be kept in the private realm?
I don't think courts have any place in the mediation philosophy. In family courts, you don't have court psychologists. It's a field of expertise which is outside the judicial expertise, and I see no reason why courts should be diluting, if you like, the purity of the judicial process by going down that path. In America some years ago, there was great popularity, what they call the multi-door court system. You had a court which was like a tower with one door led to a courtroom, another one led to a mediation table, another... The multi-door court, in which the court or the institution just took control of the dispute and decided which was the best way to go. Sounds very good, but that's not what the public want. Public want, if they go to a court, they want to have a court. If not, they go to a mediator. But the courts, I don't think, have any place to be trying to provide a whole paraphernalia of mechanisms to call in aid when parties are in conflict.
For me,
given that you are such an esteemed judge and some of the latest students are preparing to do a mock trial of their move, do you have any tips that you can give to students going before the court in regards to what they can do to get their position best across?
I think the best tip of all is preparation, preparation, preparation. It's like the real estate agent, position, position, position. The better prepared you are, the better able you are to deal with it. Now, I can give you one little example. Our greatest advocate in this country that I've encountered in my lifetime was Sir Garfield Barwick. Now, he would perfect the preparation of his case the night before. I used to work a lot with him as his junior. And he'd go up for an appellate before the full High Court, and that's a pretty imposing gathering, 7 judges sitting up there. And he'd be there for the appellate, and he'd say, well, come on, Laurence, pick me up about 9 o'clock and we'll walk up together. He used to walk up to Darlinghurst, and I'd be wanting to say, well, God, what about this, that, and the other? He said, that's all right. Now, he had totally got it in his head, and when we got into court, he'd put his robes on, and we'd go and sit down, and I'd be still as an anxious junior trying to, ginger things up, and he'd come in, he'd get up from his chair, in case he was called on, he'd walk up to the rostrum, he would have scribbled a few notes on a bit of blotting paper, and that was all he needed. He would then engage in a dialogue with the judges. And the skill of his advocacy was to get the judges to react to what he was putting. As soon as he got a judge reacting, then he had a dialogue, and he could then guide it the way he wanted to. Now, that all came from being totally prepared. Like then cross-examination. There's the story of the new barrister who was preparing his cross-examination. He wrote it, asked him, if yes, if no, this thing proliferated right on out. About the third question he got, yes and no. And the witness said, I don't know. And his plan didn't accommodate that. So you master, whether it's cross-examination or whatever, master your topic, get it all into your head, and then put your papers away, and then dialogue with the judge or with the witness in the witness box. That's the best preparation the best answer I can give to that.
When you said that courts should be separate to mediation, what do you think of court-ordered mediation?
No problem with that at all. But the court is there simply sending the parties out to be exposed to the process. Once you get one that's been sent out by the court, it's then up to the mediator to interest the parties in it and to try and get them to come with you down the path of a consensus-oriented procedure. But how matters come in for mediation, I have no constraints on. But once they're there, courts have no business to be involved. There's just one other thing I wanted to say about the court process. As human beings, we all have a yearning for due process, for fairness, of procedural fairness. And a mediator will always have that in mind when you're structuring your process. I had a very interesting mediation the other day that brought this out starkly. It was, and I'll anonymise it, a school teacher in Western New South Wales had been talking to some of her former male students in the main street about 10 o'clock at night, picked up by the police along with the students, taken back to the police station. It appears that the boys were into drugs. She was subjected to a humiliating body search, charged with some offence, came before the local magistrate, huge publicity. She was convicted by the magistrate and fined. She appealed to the local district court judge who serviced that district. When the judge came on the bench, he announced to her counsel, look, I've been through the papers and this conviction can't possibly stand. I propose to allow the appeal, the charges are dismissed. And she was utterly dissatisfied. She hadn't had her day in court. She didn't want to have a judge just say that straight off the cuff, there was nothing in it. She wanted to win the case in court. She wanted to have the opportunity of having her say and being vindicated by a judicial pronouncement. So she sued for false imprisonment and malicious prosecution. That's how it came in for mediation. So she had an action, and she was convinced that the judge and the prosecutor were in collusion to prevent the full facts coming out. Well, I could see that she was seething with resentment and distrust, and the state trusted me by giving me their last dollar, because I knew that if they offered her, say, 20,000, she wanted 40, and then they said 21,000, she'd have said, there you are, they're not genuine. If they'd hit 21, why didn't they offer it to me? So I got them to give me their last figure, which I took in, and we got a settlement for it, on it. But it's a glaring example of the thirst that most people have for due process. They want fairness in the process. Anything to do with courts is shrouded in mystery anyway. And if people are confident they're getting a fair go in court, then they're much more likely to submit to whatever happens in a court. But due process is more than just a shibboleth, more than just a rule of natural justice. It reflects a real human need. When parties become involved in disputes, they want to have due process.
If there's a significant balance of power between the parties, how can a mediator assist in resolving that, while still keeping impartiality?
Imbalance of power, that's how the cookie crumbles. If it's a bank against a customer, the imbalance is there. The effect of the imbalance will be greater probably in a court than in a mediation, because the bank can afford top quality team of lawyers and so on. You can't play God as the mediator. You've just got to do your best to try and get a consensus. Often bank officers are quite prepared to come down the path. After all, they're all human beings, to come down the path towards getting a resolution. If you as mediator will stand behind it. If they're prepared to make concessions towards the disgruntled customer, and if you'll sign off that you have recommended it to the bank or regarded as an appropriate commercial, then that little bit of extra comfort to the bank officer. But if there is an imbalance, you can't enter into the list and try and correct the imbalance, because inevitably you're favouring one side. As I say, that's how the cookies crumble. The parties have got to wear it.
I'm sure we'll all agree that there's a lot of wisdom there that we can take away and use in our future. It is a great and rare occasion that we should have a Chief Justice or former Chief Justice of the Supreme Court come and speak to us here at University of New England. Just one note in regards to the qualities that make you good at mediating. After watching your DVD, The Sous Chef, one student commented on our online discussion board that he is charming and has a Zen monk kind of calm going on. So perhaps that helps. It is particularly rewarding to be able to learn from the experience of others, and quite clearly you have extensive experience to learn from. Your website, laurensstreet.com.au, says that you've been involved in 1,500 successful mediations, so maybe that could be updated to 2,000 now, according to Paul's introduction.
It's about 10 years old, the website.
In regards to particular points of interest, I thought the 50-cent piece analogy is definitely something that we can carry on into the future as a way of looking at any kind of dispute, whether it's with a spouse or whether it's comes up to the higher realms, the higher rungs of commercial disputes. I think it's a very effective physical analogy that will bode us well.
Sometimes judges have been said to toss the coin themselves.
Also, your discussion on the contrast between the non-user-friendly court approach to decide, and the purpose of the court to decide a dispute, as opposed to mediation, which is more of a humanistic approach, which again ties back to your 50-cent piece analogy, where we might say that mediation refers to the shades, which is those humanistic relevant issues in a dispute, which I thought was particularly interesting. And then in regards to your anecdotes, they're all particularly interesting, but the anecdote about the hole in the fence, I think that really shows the importance of mediation, and it's kind of the worst case scenario of what could happen if disputes are left to fester. And it was quite dramatic, but I think that it definitely put that into perspective as how important mediation actually is. So we would like to offer you a gift, just to show our appreciation, and that's just a bottle of local high country Sauvignon Blanc and pasta.
Well,
and from the local area. Thank you very much.
Well, thank you very much.
And if we could all please show our appreciation for Sir Laurence Street.